Good morning, Your Honor. This is Alan Figueroa, State Certified Prosecutor Interpreter.
Has the interpreter been sworn?
Yes, Your Honor.
All right, please connect with the headset.
Connected, Your Honor.
Sir, please tell me your name.
Álvaro Noé Ruiz. Noé Ruiz.
Alvaro Noel Ruiz.
This is 21 CF 13460. Ma'am, do you need an interpreter?
Yeah, yes, ma'am.
All right, could I have the interpreter please disconnect from the headset?
Yes, Your Honor.
Thank you. I have a witness now, and I want to make sure that she can understand the proceedings. All right, Mr. Ruiz, you're here charged with domestic battery by strangulation, false imprisonment, domestic violence, and battery domestic violence.
Bien, señor, se encuentra aquí por los cargos de violencia doméstica por estrangulación, agresión física en violencia doméstica y por privación de libertad en violencia doméstica.
I'm going to appoint an attorney to represent you.
Se le designará un abogado para que lo represente.
Sí, señor.
There is probable cause in this case.
Determino que existen indicios de criminalidad en este caso.
Ma'am, do you wish to testify?
Señora, ¿desea testificar?
Sí, claro.
Yes.
Before we continue with her, can the interpreter please instruct the defendant that he is to look at me and not the witness?
Antes de eso, señor, por favor, mire a la jueza, no mire a la testigo.
Yes, ma'am.
All right, thank you. Ma'am, raise your right hand.
Levante la mano derecha, señora. ¿Jura decir la verdad, solo la verdad y nada más que la verdad?
Yes.
All right, Miss May.
Yes, Your Honor. Good morning. Can you please state your name for the record and spell your last name?
Buenos días, por favor diga su nombre para que conste en actas y deletree su apellido.
Erika Gómez, G-O-M-E-Z.
Erica Gómez, G-O-M-E-Z.
Thank you. And what is your relationship to Mr. Ruiz?
¿Y cuál es su parentesco en relación con el señor Ruiz?
Estamos comprometidos hace 3 años.
We've been engaged for 3 years.
Are you afraid of him?
¿Usted siente temor de él?
No.
No.
If you were to be released from custody today, would you be afraid of him?
Si él fuese a salir de la cárcel hoy, ¿usted sentiría temor de él?
No.
No.
Has anything like this ever happened before?
¿Acaso algo como esto ha ocurrido en el pasado?
No.
No.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Si algo como esto o algo más severo ocurre en el futuro, ¿usted llamaría al 911?
Sí.
Yes.
Do you believe drugs or alcohol were involved in this incident?
¿Cree usted que las drogas o el alcohol tuvieron algo que ver con este incidente?
Sí.
Yes.
El alcohol.
Alcohol.
All right. And do you want to have contact with Mr. Ruiz while this case is pending?
¿Desea usted tener contacto con el señor Ruiz mientras este caso esté pendiente?
Sí.
Yes.
That's all I have, Your Honor.
Es todo lo que tengo, señoría.
Anything from the defense?
¿Algo de parte de la defensa?
No questions, Your Honor.
No tengo preguntas, su señoría.
All right, Mr. Ruiz. Thank you, ma'am.
Gracias, señora.
Mr. Ruiz, your bond on count 1 is $5,000.
Señor Ruiz, su fianza ante el primer cargo es de $5,000.
Count 2 is $1,000.
$1,000 ante el segundo cargo
Count 3 is $100.
y $100 ante el tercer cargo.
You can have no contact with the victim. Do you understand what no contact means?
Se le prohíbe el contacto con la víctima. ¿Entiende lo que eso significa, señor?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition.
Se le prohíbe la tenencia de un tipo de arma, arma de fuego o municiones.
You can't possess or consume any alcoholic beverages.
Se le prohíbe la tenencia o el consumo de ningún tipo de bebida alcohólica.
You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings.
Se le permitirá regresar una sola vez a la propiedad junto a las autoridades para recoger sus pertenencias. Tiene que buscarse otro paradero.
At this time, however, you have an immigration hold.
pero usted tiene una orden de retención de parte de inmigración,
so you won't be released until that hold is released.
así que no podrá salir de la cárcel hasta que se arregle el problema de esa orden de retención.
Good luck, sir.
Buena suerte, señor.
Thank you for coming, ma'am. Good luck.
Gracias por estar presente, señora. Buena suerte.
Can the interpreter connect with the headset, please?
The defendant can hear me, Your Honor.
Thank you. Sir, please tell me your name.
Jeremías Pérez Hernández.
Jeremías Pérez Hernández.
21 MM 7236. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you.
Okay.
Your bond is $2,000. You can have no contact with the victim. Do you understand what no contact means?
Sí.
Yes.
You can also have no contact with any witness in this case, which includes the two children who were present. Do you understand that?
Sí.
Yes.
You must comply with any plan set in place by DCF. You cannot possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I will allow a one-time return with law enforcement to gather your belongings. You cannot possess or consume any alcoholic beverages or any controlled substance without a valid prescription. At this time, I'm revoking your bond in 20 CT 3843. Good luck, sir.
Yeah, the lack of substantial criminal history, would you consider revoking out of bond and setting, doubling the monetary bond?
I would not. Good luck, sir. Thank you. Sir, please tell me your name.
Freddy Magadiel Pérez Ortiz.
Freddy Magallanes Perez Ortiz.
21 MM 484. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you in this case.
He does otherwise qualify for PTR, Your Honor.
Does the state object?
Your Honor, state's main concern is there was an allegation of alcohol use, there's an allegation that children were present, and there's an allegation of unreported history. So if you are inclined to put them on PTRs, that that's for bond with.
Sir, I'm going to place you on pretrial release and require that you post a monetary bond. However, I'll reduce that amount to $1,000. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Sí.
Yes.
You can't possess a weapon of any kind, firearm or ammunition. You cannot possess or consume any alcoholic beverage or controlled substance, and you'll be subject to random drug and alcohol screens while on pretrial release. You must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. You must comply with any plans set in place by DCF. You can have no contact with any witness in the case, and that includes the minor children. Do you understand that?
Sí.
Yes.
Good luck. Please tell me your name.
Robert Soto Rosario. Robert Soto Rosario.
Robert Soto Rosario.
A warrant was issued for your arrest for violating your probation in 2019 CF 16809. The allegation is that you failed to successfully complete or remain in drug or alcohol treatment. There's no bond, and I will appoint an attorney to represent you. What is this other case? Why does it say there's a detainer?
It's out on RR.
But was he out on, when was this warrant issued?
Arrest on the out on bond case was 5/23/21.
I believe he was released ROR in 7/20.
But what about this violation of probation? I gotta go back into that affidavit. When is it alleged to have occurred? On or about, September 10th. All right, I'm going to revoke that ROR in 21 CF 6036.
You said a 0, Your Honor.
Yes. And I'll appoint the PD in case they weren't. Good luck, sir. Please tell me your name.
Juan Manuel Sánchez Carbonell. Juan Manuel Sánchez Carbonell.
Juan Manuel Sanchez Carbonell.
A warrant was issued for your arrest in 20 CT 864 for violating your probation by failing to comply with all instructions given, including failing to keep scheduled appointments, failing to pay, failing to complete the DUI counterattack school, the victim awareness program, 50 hours of community service, and failing to comply with the condition of the court's collection program. At this time, there's no bond, and I'll appoint an attorney to represent you.
Your Honor.
Yes.
I have notes from our office that there was a hearing on this on September 27th, and there was a bond set by Judge Allen of 2,000. The hearing was set for October 21st, so I believe there's a bond on this.
So why is he here?
I'm not sure. I was told right before court that this order was on the docket or in the case file. Excuse me. Then I double checked to make sure that our office had that in there. I have the order.
I mean, if he's already been seen by a judge, he doesn't need to be here.
I understand. Yeah. I wasn't aware until I came into court.
Anybody have any ideas?
I can see if I have any notes, Your Honor.
May I approach you, Honor?
Yes. Hold on. That's this? Is that this? Okay, the clerk just handed this to me. It says minutes on Thursday, October, oh, no, that's what the hearing is set for. On September 27th, the defense moved for bond. I'm really confused by this. Hold on a minute. So the warrant was issued September 21st, and this hearing happened September 27th. So then why is he here? Nobody knows?
No, Your Honor. I'm looking up just the court minutes, the ordinance motion, but
Yeah, I'm looking up all this stuff too, and I can't figure out why he's even here. But but he was there on 9/27. All right, well, this is not making any sense to me, but your bond is $2,000. You have an attorney representing you. I suggest you call your attorney and see if they can figure out what's going on. All right, good luck, sir. Thank you. I mean, if he appeared on the 27th, he doesn't need to be IA'd. So this doesn't make sense unless there's a new warrant, which I didn't see. I'm sorry? All right, so we're done with Spanish? All right, that's all we have for the interpreter. Thank you.
No problem, Your Honor. Thank you.
I'm sorry, what? Yes, that's great. Morning, Counselor, go ahead.
Good morning, Your Honor. We'd like a bond set on this case. I don't agree that there's probable causes to a burglary charge because he has a key, it's his daughter's house, and he has permission to be there. So,
Do you want to tell me who he is and
oh, I'm sorry.
put
I'm
your appearance on
Bradford
record?
Fisher. Let's start with that. I'm Bradford Fisher. I'm appearing at this IA for Mr. Hoskins. And he is my client. He was arrested on a burglary with an assault or battery charge, an aggravated assault charge, and I can't remember the third count.
John Hodgkin?
Yes, Your Honor.
All right, this is 21 CF 13457. Sir, you're here because you were arrested on charges of burglary of a dwelling with assault or battery with a firearm, aggravated assault with a firearm, domestic violence, and battery domestic violence. All right, Counselor,
Bradford Fisher, Your Honor.
right, you're arguing there's no probable cause for,
Not on a burglary. He has permission to be there. He has a key. It actually, in the report, says that he goes over there routinely and so on. So if he has permission to be there, it can't be a burglary. It's his daughter's house. And in fact, it's his wife that's taking care of their grandkids that's at the door in the report. Now, obviously, the court needs to have no contact, and I can understand a significant bond.
what says the state?
Your Honor, I don't believe The fact that he was allowed to be there is present within the four corners of the affidavit, and PC has to be found.
Wait, I can't hear you at all.
I don't believe there's an allegation within the affidavit that he had permission to be there. I believe there was a text conversation between the defendant and the victim, where he said that he is not coming over, even though the victim gave him permission. He said, I do not want to go over there because he is not worth spending the rest of his life in jail. So he was instructed to give the firearms to the wife, who would be dropping off the two children. He came unannounced. So there's no allegations within this affidavit that the defendant was granted permission to be here, nor had a key.
In fact, Your Honor, the state just reiterated permission directly from the alleged victim. Whether or not my client initially decided to take him up on it or not, it's even the victim agrees that he had permission to be there and invited him. On top of which, if you go on, according to the detective that interviewed my client said that he goes over there routinely. So he has standing permission to be there. It can't be a burglary.
Do you have any case law to that effect, Counselor?
This is basic as to the statute. A burglary requires it to be trespassing, Your Honor. The very first requirement of a burglary is that you be there without permission. The
Your Honor.
second aspect is that you have an intent to commit a crime.
Your Honor, state would, according to defense's argument, that when the detective interviewed his client, he said that he was allowed to be over there. His story changed quite a bit during that interview, saying that he has routine encounters with the son-in-law, and then the statement began to change. He then consented that things were different at this time, and that he'd gone over to get his property, but was concerned about how the victim would respond, and then said he had to arm himself because he was worried about how he would respond. State contends that if he has to arm himself before going into someone else's house, he arguably knows he does not have permission to be there. He entered stealthily after the wife entered, and that's when the battery occurred.
There's no allegation that in the affidavit that he entered stealthily. In fact, it's 4 o'clock in the afternoon. In addition, the burden of proof is on the state, not the defense, to show that he did not have permission to be there. And nowhere in the affidavit is there anything saying he did not have permission to be there. It's an actual family member, even if they're not getting along. The only,
Counselor, are you arguing that you can't break into a family member's home?
of course you can't, but the burden of proof is on the state to show that he did not have permission. The victim himself in the affidavit says, come over and get them yourself. And my client, according to the victim, made an alternative proposal, but even the victim is agreeing that he wanted him to come over. And my client said that he had permission to be over there because he says he comes over there routinely. And it's his daughter's house. All of this common sense is permitted in evaluating these sorts of things. And the only allegations in the actual affidavit are, in fact, that he had permission to be there. The state wants to do an inference that he may have expected trouble, but even if that's the case, he still had permission.
Your Honor, state would contend that he did enter stealthily, not due to the day or time, but due to the defendant's wife, Lori, came to the residence to drop off the two children. She had come alone with the children, no indication that the defendant would be coming over. He took his children, took the youngest one to the master bedroom to change the diaper. The defendant's wife was on the opposite side of the house. He heard a loud bang on his front door. The defendant's wife would not cooperate with law enforcement and discuss anything further. And then he turned around and the defendant was in the master bedroom.
A loud bang on the front door is the opposite of stealthy entry, and it's 4 in the afternoon.
If he had permission to be there, why would he be knocking or trying to enter with a loud bang?
Okay. People normally knock on the front door before they enter, Your Honor. I mean, obviously, I agree there needs to be no contact. Obviously, the court is going to need some sort of substantial bond and release conditions. I understand that, but there is not probable cause of burglary.
All right, so I pulled out the statute. I'm reading the statute and the jury instructions. So give me one moment. So it says, for purposes of the record, the statute reads 810.02. Burglary means entering or remaining in a dwelling, a structure, or a conveyance with the intent to commit an offense therein unless the premises are at the time open to the public or the defendant is licensed or invited to enter or remain. So I was going back to the jury instruction to see if it gives us any help on license to enter or remain. All right. It is a defense to the crime of burglary if the defendant was licensed or invited to enter or remain. The state has the burden of proof beyond a reasonable doubt the defendant was not licensed or invited to enter and remain. But that's beyond a reasonable doubt, like that's a trial standard. This is probable cause. So I need to read this portion of the affidavit again. Give me a moment.
Thank you, Your Honor.
So the jury instruction also says, hold on, I need to read this. If the license or invitation to enter was obtained by defendant's trick or fraud or deceit, then the license or invitation to enter was not valid. The reason I'm reading that is, I'm going back to the affidavit. It says, the victim invited the defendant to come over. The defendant said, "I'm not coming to your house." And the defendant's last communication was instructions for the victim to give the firearms to someone else because he would not be coming to the house. And then the victim says he turns around and the defendant is in his bedroom. So was that a trick? Was the license revoked? And remember, we're just here for probable cause. This is not beyond all reasonable doubt.
I understand.
So whether
Your
the
Honor.
state can sustain this at trial is a very different question.
I understand, but it's very relevant to getting a bond today, Your Honor, which is why I'm pointing it out here and now rather than waiting. Remember, you also have my client's testimony to the detective, that according to the detective, my client says he comes over routinely. You have his wife there babysitting the children, and yes, it's his son-in-law, but it's also his own daughter's house. It's not unexpected that he might have standing permission to be there.
But I also don't think that's,
That's not within the affidavit, therefore that cannot be determined for PC purposes, Your Honor. And the detective even said that the defendant's statement began to change after he said that this is a routine encounter with his son-in-law. His statement began to
Nowhere, if
change.
we're going to stick to the four corners of the affidavit, nowhere in the affidavit does it say that the invitation was revoked.
But from Your Honor's own
The state,
reading,
sorry, go ahead.
it can be from, as you stated, in the jury instruction, it can be by trick, fraud, or deceit. Your Honor, the state would also contend that while it doesn't say it's also the daughter-in-law's house, I don't believe within this affidavit, it doesn't say he has a key within this affidavit, And it does appear that the victim did give him permission to come pick up his firearms, to which I already read for the state that he's not coming. It's not worth me spending the rest of my life in jail, was the defendant's answer. And they decided on giving the defendant's wife the firearms. So it is by deceit or trick that he is now in his house, because that invitation arguably was revoked when he said, I am not coming, and now he's standing in his house unannounced.
I'm just trying to determine if it's reasonable that just because you're related to someone, and at one time they gave you permission to come over to their house, is it reasonable to turn around and find them in your house when you're not expecting them there? Is that a burglary? I kind of think that's a jury question.
Not if the person has a key. And it's
Where does
not-
it say that, counselor? Can you show
I agree
me?
that that's not in the affidavit.
Therefore, it cannot.
So then there's no evidence before this court that he has a key?
I agree. Here and now, I agree.
Okay.
But the finder of fact, which today is the court, is allowed to use common sense in evaluating it, and this is his son-in-law. His daughter also owns the house and also has authority to give permission.
Where is that in the affidavit?
Hold on.
Okay. I'm trying to find it right now.
It doesn't say that there's a key, nor, I believe it doesn't say that the house is
Hold on.
shared. Nor did the daughter-in-law ever give a statement.
Mother-in-law.
Dispatch had received a call and referenced a father-in-law. By definition, that makes Mr. Hoskins his son-in-law, and by definition, that means what is the name of the victim? All right. By definition, the victim is married to my client's daughter. It's almost the very first paragraph of this report, maybe 5 sentences down.
Right. I don't think anyone's disputing the relationship.
Right.
What I'm asking is, where does it say that the daughter owns the house or lives in the house and gives him permission?
If you're married, under Florida, it's a tenancy in the entirety, and they have authority to have complete authority to invite people over. So if I get married to someone and it's my apartment, we live there, the person that I'm married to, has authority to bring somebody over in Florida property law.
It still never says.
That's inherent to being married. And it can't be a father-in-law, he can't be a father-in-law if his son-in-law is not married to his daughter.
Right, but it doesn't say she lives there, does it?
Nor does it say
It
that she ever
wouldn't-
gave him permission.
It wouldn't matter whether or not she lived there or not, she would still have complete authority as the daughter. And again, we're back to the state has to show that he did not have permission, and the court is allowed to use common sense in interpreting this.
I agree, and I think I can use common sense, but I think you're asking me to consider facts that I don't have. So that I'm trying to figure out where those facts are. Does it ever say anything about the daughter?
No, Your Honor.
No, the daughter's name and the statement of the daughter never appears in the report, because the conflict was between my client and his son-in-law.
Okay. Okay. All right, here's what I'm going to do. I appreciate the arguments from both sides. Well, I thought I knew what I was going to do, but give me another minute.
The court is never wrong. Never wrong.
Well, it is a really unique circumstance. For this court, what makes the difference is the fact that the victim said, I told him to come over. So there was clearly an invitation. However, then your client says, I'm not coming over there. So that's a declination of the invitation. I don't know if that revokes the invitation, but I think it means The victim had no reason to expect that your client would show up and be in his house because he said he wasn't coming. So here's what I'm going to do. I'm going to find probable cause for the burglary of a dwelling with assault or battery, aggravated assault with a firearm, and battery. However, I'm not inclined to hold your client at no bond.
Yes, Your Honor.
Your Honor, state would, in the alternative, ask for a high bond, given that it is a first-degree felony punishable by life, and given he does have prior criminal history of violent offenses.
I see an aggravated assault in 2005. Is there anything else?
I'm checking, Your Honor.
And while you're looking, let me ask, Counselor, are you intending to take any testimony to argue for bond or just argue?
Yes, I'm going to take some testimony. Sir, how long have you lived in Central Florida?
We need to have him
Has he
sworn
been
in.
sworn?
Oh, I'm
Raise your
sorry,
right
I
hand. It's okay.
apologize.
It's all right. Raise your,
Yes, ma'am.
all right, go ahead.
How long have you lived in Central Florida?
Me personally, 55 years. The family's been here 140 years.
Do you have any family outside of Florida?
No, sir.
Okay. What do you do for a living?
I'm a commercial licensed contractor. I build marine structures, seawalls, bridges, do a lot of work at Disney and Celebration.
Do you work for yourself or do you work for a company?
I work for myself.
Okay. And is your company here?
Yes, sir.
How long has the company been around?
37 years.
Do you have a passport?
Yes.
Okay. Does your wife live here?
Yes, sir.
Are your grandchildren here?
Oh, yes.
Are your children here?
Yes.
Do you have any reason to leave the state of Florida?
None whatsoever.
What bond can you afford? How much money do you have in the bank?
I think we might have $25,000 or $35,000. I'm not sure. Lori controls all the money. I never really know what we have or don't have.
Do you have a house?
Yes.
Do you own it?
Yes.
Do you know what the equity in the house is?
Yes.
What
It's
is it?
about, realistically, it's going to be somewhere around $800,000.
Your Honor, I've provided the court with testimony as to his resources. He has no contacts outside the state of Florida. His entire family life and business is here. We would ask for, I understand, whatever terms the court wants to set. Obviously, I would recommend no contact, no weapons, no return,
None.
just for starters. But I don't know exactly what terms the court is looking for. I just don't think he's a flight risk. I think the bigger concern is whether or not anything else could happen.
Right, and I don't see this in the affidavit either, and I don't think you elicited this testimony, Counselor, but how far away from here does your client live, from where this took place?
Would you answer the court's question?
Yes, ma'am. I am 2 houses to the north.
So they live,
We're 5-acre tracts on Beulah.
Oh, so more than 500 feet.
Oh, yes, ma'am.
And you don't need to come on that property to get to yours?
No, ma'am.
Okay.
No, the only one that has to go on that property is Mrs. Hodgkin because she babysits the grandsons while my daughter and my son-in-law are at work.
just one sec. If you want to leave your residence, do you have to drive by their residence in order to leave the area?
No,
Okay, so there's no need for you to ever be within 500 feet of that residence?
none whatsoever.
All right, any questions, Ms. May?
No, Your Honor.
Any argument?
State would just argue, one, the allegations in the affidavit are concerning. The defendant's own statements to law enforcement changed multiple times. There was a firearm alleged in the affidavit. There also was a firing of the firearm to which the victim got grazed, which is an aggravating factor for this case. Mr. Hodgkin does have some prior criminal history. He had a 2004 ag assault and grand theft that I believe was pled down to a disorderly conduct. That was an ag assault, I believe, with a motor vehicle. And then he had, in 2011, there was a non-arrest felony that came through. Ag assault with a deadly weapon, also a different victim. That case was declined to prosecute due to the victim being unwilling. But he does have prior cases of at least arrests for violent offenses. I understand the testimony here is that he believes he has a key. He believes he has the ability to be there. However, the facts in this case are pretty aggravating, and the fact that he felt he had to arm himself before going to pick up other firearms from that house can lead the court to believe that potentially he knew he was not supposed to be there, having to arm himself and enter after the other party entered, and the victim was busy. State would just ask for a high bond. Given all of that, you heard the defendant's testimony as to he has fairly significant monetary contributions that he could put towards his bond. And given that he is charged with an F1, I believe an F3, and an M1, state would just ask for high bonds.
All right, thank you, Ms. May. Go ahead, Counselor.
Briefly, if he wasn't arrested and the case wasn't prosecuted, we don't know what the reason is it wasn't prosecuted. How about it didn't really happen? So that's the first point. Second, if there was an arrest for aggravated battery, but they pled it down to disorderly conduct, that might suggest there's no aggravated battery or aggravated assault there either, or they wouldn't have pled it down. So the actual evidence in front of the court is that he has a prior disorderly conduct and I guess a 2005 aggravated assault.
Right.
And again, I think that the real issue is making sure he doesn't return as opposed to being a flight risk, which is what usually the purpose of the monetary bond is, Your Honor.
Right. So thank you both for all of that information. Here's what I'm going to do. Count one, sir, your bond is $150,000. Count two, it's $5,000, and count three, it's $100,000. With special conditions, you can have no contact with Trevor New. Do you understand what no contact means?
Yes, ma'am, I do.
And you've just told the court that your wife works there and takes care of your grandkids. So I want to make sure you understand you can't send a message through your wife.
No, I understand.
All right. And your attorney can further explain that to you just if you have any questions, but I want to make sure you understand that because it's a very unique situation.
I
With your wife still going over
understand, and
there.
I'm not going to, in any way, shape, or form, jeopardize my
Right.
standing with you.
Right, because that's what's at risk here. Right.
Oh,
You can't possess any weapons, firearms, or ammunition. Did the law enforcement officers secure the weapon that you had that night?
ma'am, I believe they did. I don't know. I took a pretty good beating. I was in the hospital last night.
Don't talk.
Oh,
Your Honor, it's alleged in the affidavit, the last line, that the Glock 21 was collected with additional ammunition.
Okay, all right, that's what I wanted to know. So they have that gun. You can't possess any other weapons, firearms, or ammunition. DCF was called. I understand you're not a parent to the children, but there were children present. So if DCF puts a plan in place that affects you, you'll have to comply with that. You can't be within 500 feet of the victim's residence or place of employment. Was your daughter present for this?
She was not, Your Honor, at least to my
Okay.
understanding.
The only reason I'm asking is, the only other witness I see, adult witness, is his wife. At this time, I'm not going to order no contact with her.
thank you.
I just want to make sure I'm not missing any other witnesses. Are there any other conditions the state would request?
No, Your Honor.
All
Where
right,
does the victim work?
I don't know. I was assuming he would know, their family.
Family.
Where does he work?
He's self-employed landscaping.
Okay.
Maintenance.
And isn't to come within 500 feet of the residence, and I assume he's not to come within 500 feet of the alleged victim if he randomly encounters him?
Well, yeah, I mean, it's no contact, so just,
Fair
if you
enough.
see him, turn around and go the other way. Because you're the person with everything at risk. The court doesn't have jurisdiction over him.
One other
So if you
question.
guys have a conversation, he's not being arrested and held at no bond. You potentially are.
Do you own any other firearms other than the one the police collected that are in your residence?
Yes, I do.
Okay. How many guns are there?
In the residence? there's-
Wherever, anywhere
okay,
that you
Trevor-
possess a gun other.
Trevor New has possession of 8 or 9 long rifles.
Okay. Stop for that.
Okay,
Those are ones in his possession. Okay.
correct, but they're mine.
I understand.
Okay.
Any other weapons you have that were not in the victim's residence, how many are there?
I would say 6.
Okay. Who can you surrender those to? Do you have someone that you can give them to keep until this case is entirely over?
I am actually going to drop them off with the owner of the armories, Lewis, and I'm having everything sold.
Okay. And how quickly can you do that upon release?
That will be done as quickly as I can get to my house and empty the gun safe and safely transport
So
everything.
you
to
can't
him.
transport anything, that's part of the court
Oh.
order here.
Your wife is going to have to do it
Your
or
wife would
someone
have to do
else?
it. How quickly
Yeah.
can she take care of it?
It could be done today, ma'am.
Okay.
So-
Then I'll order that has to be done within 48 hours of your release.
That-
Your Honor, state would also ask that he surrender his passport, given that it is a punishable by life felony, and he did testify that he did have one.
I'll order that. That's reasonable.
I'll give up my concealed license too.
Hold on. Who do you want him to surrender it to, Your Honor?
Is it the county? I'm sorry, Orange County?
Yes, Your Honor.
Orange County Sheriff's Office.
You'll have to give your passport to Orange County Sheriff's Office, do you
No,
understand?
that's fine. Yeah, just go inside the SO's office and
Right.
then it,
Thank you, Your
You'll
Honor.
have a court order, so you can take that with you.
okay.
Thank you, Your Honor.
Yes, sir. Thank you, Counselor. Good luck, sir.
Yes, sir. Thank you.
Yes, sir. Please tell me your name.
Isaiah Clark.
You're here because a warrant was issued for your arrest in 21 CF 13126, charging you with aggravated battery with a firearm and aggravated assault with a firearm. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Give me one moment. Your bond is $25,000 on count one, $5,000 on count two. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm or ammunition. You cannot have any unsupervised contact with any minor child under the age of 18. You must surrender any firearms or ammunition that you have to law enforcement within 24 hours of your release. You must comply with any plan set in place by DCF.
Yes, ma'am.
Any other conditions the state would request?
No, Your Honor.
Good luck, sir. Hold on, bring him back in here for a second. What does it say? All right, in the original warrant, the judge ordered that you're not allowed to have any contact with not only the victim, but any of the victim's children. I will continue that order.
Yes, ma'am.
Good luck. Thank you. Please tell me your name.
Joshua Coburn.
21 CF 13288. You're here charged with aggravated battery on a pregnant person. A warrant was issued for your arrest, so another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Your bond is $10,000. You can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. Any other conditions the state would request?
No, Your Honor.
Good luck, sir. Please tell me your name.
Jordan Fair.
21 CF 13456. You're here charged with tampering with a witness to hinder communication to law enforcement, robbery by sudden snatching, and battery dating violence. I'm going to appoint an attorney to represent you in this case. There is probable cause. Your bond is $5,000 on count 2, $150 on count 1, and $100 on count 3. You can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Yes.
You can't possess a weapon of any kind, firearm or ammunition. Were you two living together?
No.
All right, you can't be within 500 feet of the victim's residence or place of employment. Do you understand?
Yes, I understand.
Any other conditions the state would request?
No, Your Honor.
Good luck, sir. Look at me, and please tell me your name.
Tyrone Grooms.
21 CF 13417. You're here charged with aggravated battery, domestic battery by strangulation, and resisting an officer without violence. I'm going to appoint an attorney to represent you. Did you wish to be heard, Mr. Brantz?
Yes, Your Honor. As to probable cause on count 1, aggravated battery, I read through the affidavit and saw that there was evidence of bloody eyes as well as punches, swelling. But I believe aggravated battery requires great bodily harm, which I have some case law that better defines that. The definition the court gives, if I can approach, Your Honor.
Yes, please.
This is a 1974 case, 289. Other cases cited the same definition. I tried to go as far back. But I've highlighted towards the end of the opinion, Your Honor, for the court. Great bodily harm defines itself and means great as distinguished from slight, trivial, minor, or moderate harm. As such, does not include mere bruises as are likely to be inflicted in a simple assault and battery. Although it is a jury question, I believe that great bodily harm, permanent disability, or permanent disfigurement is not included in that arrest affidavit. So I would just have you find PC as to a simple battery.
What says the state?
Your Honor, state would argue that having bloody eyes is more than slight or moderate or minor harm. It didn't say she had a cut and her eyes were bloody, or that there was like a cut above her forehead and it like bled into her eyes. She's had blood in both of her eyes as well as the swelling. State would argue that it's more than minor or moderate that the defense counsel has argued. He doesn't have any case law saying that that in particular is not. Therefore, I believe it's a factual determination.
Your Honor, as to that argument as well, I have some case law. It's a little longer. It's from the 11th Circuit, Federal 11th Circuit, if I may approach on this as well.
It's a federal case?
It's a federal case, Your Honor, yes, but I believe it's our circuit, the 11th Circuit.
I'll review it.
Profusely bleeding head wounds suffered by a victim would not have appeared slight or trivial to a reasonable officer. And so I took the phrase profusely bleeding. That wasn't included in the arrest affidavit either. But have you consider the severity of profusely bleeding versus blood in the eyes?
Your Honor, we don't have a head wound that was bleeding in this case. We have her eyes actually bleeding. State would contend that's very different circumstances from having a laceration on her head and it profusely bleeding versus her eyes actually bleeding in conjunction with all the other injuries she sustained. She was bleeding from the eye and was unable to see. There were firearms and machete in the home. SWAT had to breach the door. She was placed in a chokehold that restricted her breathing. The officer says she had obvious facial injuries, included both blood in her eyes and swelling.
Can the defense point me to where in this case you want me to focus my attention?
The Court of Appeals case, Your Honor?
Yes.
I used Head Note 3, which I believe, I know it's a longer case, I believe is on page 5. Head notes indicate that the second column, third paragraph is where their discussion begins.
But where does the court discuss that? So I see that where I'm looking at is what I think you just pointed me to, but that's the background of the case. That's not the court's opinion analyzing that language. Can you point me to where that is?
Yes, Your Honor, just a moment.
Okay.
I believe their discussion is contained in that paragraph. They say Officer Welker testified at his deposition that when he arrived at the laundry, he saw white female sitting in a chair bleeding profusely from the head. So that's where they get the quote in the head note. Officer Welker asked Capuano what happened, and through her crying, Capuano said someone had hurt her. She indicated by pointing with her thumb that her assailant was inside the laundry. Hossein also indicated that the assailant was in the laundry wearing a green shirt. Officer Welker testified at his deposition that from the look of Capuano's injuries, it was possible that an aggravated battery, a felony, had been committed. I don't know if they discuss it, but they state it in a way that I believe the court assumes that profusely bleeding was enough for an officer to reasonably assume that an aggravated battery had taken place. I would assume it's also a jury question, but for this court's analysis, I would just have you look at that case as well.
Your Honor, if I may briefly, as defense has already said, it's slight, trivial, minor, or moderate harm. Doesn't include mere bruises. Here, we have her bleeding from the eyes, not bleeding from her head, which is arguably distinguishable. The Owens case from the 2nd DCA says that it is a question for the jury. Today, we're just here for probable cause, which is extremely low, and whether you determine that bleeding from your eye is more than slight, trivial, or minor, state would contend that it is. In the Coronado case from the 2nd DCA, it was alleged that a victim had a black eye, and the court held that the injuries met the definition. They find no error, that it's a question for the jury for them to determine if that was sufficient. So as that would be a question for the jury, the only real finding you need to find here today is whether you think bleeding from the eyes is more than slight and trivial. And we've had no case law directly on point saying that bleeding from your eyes is, state would contend, is more different than the case law defense provided from bleeding from your head.
Well, I think the key is bleeding from the eyes and unable to see. So,
And the phrase I use, the reason I present the federal case law is the phrase profusely bleeding, like actively bleeding nonstop.
It's still different than bleeding from your eyes.
As opposed to blood in the eyes, which is what the phrase in the affidavit. Capillaries may have burst from the swelling.
well, it says up on the, hold on. I'm looking at the,
I understand, Your Honor. It also says that when they called, she had blood in her eyes and could not see.
in the third full paragraph, she was bleeding from the eye and was unable to see. And then it later says, she was seen to have obvious facial injuries, which included blood in both eyes and swelling.
Your Honor, state would also point to just the totality of the circumstances in this case. Law enforcement was originally called to scene at 22:10. Were not able to make way into the apartment. Came back at 12:22 a.m. the next day. We're also not able to get in, and her phone was no longer in service. So at 2:08 a.m., there was another call initiated. Her phone was out of service, and that's when SWAT was called and was able to gain entry into the house at 4:03 a.m. So this incident arguably went on for approximately 6 hours with her having these injuries unknown of when they were sustained, before the first call, during these calls. However, having blood in both of her eyes, unable to see, and facial swelling over that long of a period of time, state would contend that it's more than slight or trivial or minor.
Can I speak?
Just a moment, ma'am. If you want to testify, I'll allow that in just a moment. First, we're just having the legal argument. So let me get through that. All right, so I'm looking at the Owens v. State, which surprisingly from 1974, there's no negative treatment of this?
Well, Your Honor, the thing, I kept going back, I would find a recent case that quoted another case that quoted this case. So I just kind of went to the original.
But no, it's not, no negative treatment.
I don't believe so, Your Honor.
Okay.
They are citing, or they are quoting.
Pretty old, so.
They're quoting a statute from Indiana, or an Indiana case. But they use it as, I believe, supplemental material to make their determination persuasive.
I believe it's just the first time that we get the definition of great bodily harm, of the slight, moderate, that was then used through several cases since.
Okay, hold on one second. As to point 3, raised by appellant, that the victim's injuries were not so serious as to constitute great bodily harm, permanent disability, or permanent disfigurement, it is noted other jurisdictions have considered this subject as follows. So that's when it looks at the case you're talking about.
Are you back in the federal case, Your Honor?
No, I'm in the Owens v. State.
I'm sorry.
It says, defendant asserts that great bodily harm is synonymous with permanent injury. It could be argued that all permanent injury constitutes great bodily harm. It does not follow, however, that all great bodily harm consists of permanent injury, although many have lasting effects.
Yeah, I believe in this case, Your Honor, the victim had a broken nose, one eye completely shut, couldn't see out of the other, lip was and it had a busted lip. Arguably, with Florida case law today, due to having a broken nose, that's permanent disfigurement, and it would be great bodily harm. But it's not really on point with the injuries that we have today.
Yeah, I think that the broken bone is universally accepted as great bodily harm or permanent disfigurement. All right, so in reading the section that you highlighted for me, Mr. Brantz, it says, distinguished from slight, trivial, minor, or moderate harm, and does not include mere bruises, which are likely to be sustained by a simple assault or battery, and that's a question of fact for the jury. So just looking at this case, and then the facts that we have here in this affidavit, it's, I think, obviously more than mere bruises. I think bleeding from the eye, unable to see, eye swollen, I think that's more than mere bruises. So I think there's probable cause. However, I don't know if if the state can sustain it at jury trial. I don't know if they can get past probable cause. All right. So I do find there is probable cause. Ma'am, do you wish to testify this morning?
Yes.
Please raise your right hand.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Go ahead, state.
Good morning, ma'am. Can you please state your name for the record?
Sanai Perry,
And can you please spell your last name?
Perry.
And what is your relationship to Mr. Grooms?
He's my boyfriend.
Has anything like this ever happened before?
A smaller situation,
Approximately how long ago would you say that was?
February.
I'm sorry?
February.
Are you afraid of him?
No.
I'm sorry, I couldn't hear you.
No.
Are you willing to call 911 if anything like this or anything more severe ever occurred in the future?
Yes.
Do you believe drugs or alcohol were involved in this incident?
No.
And do you want to have contact with Mr. Grooms while this case is pending?
Yes.
Right, thank you.
Anything from you, Mr. Brands?
No questions, Your Honor.
All right, was there anything else you wanted to tell the court, ma'am?
Yes, I just wanted to add specifically, I never said I could not see out of my eye. I said it was blurry and I was not bleeding out of my eyes. I have like kind of like a blood vessel in both. So it wasn't necessarily like I can't see, I'm bleeding and traumatized like that. That was extremely traumatized.
All right, thank you.
Thank you.
Your Honor, when,
What happened with his kidnapping, false imprisonment, aggravated battery, arrest? I don't see any convictions for those things.
he also has a,
But what happened to them? Because I don't see any violent convictions.
yes, Your Honor.
Did the state just drop it?
Well, he has an open petty theft currently. He has 1995.
I don't see that anywhere either.
12, 1995, no, it's orange. It's
I
a
don't see
petty
that.
theft of 100 or more. It is 21 MM 598. It was in KPS, it was recalled.
Just a moment, Your Honor.
I still have it open on case management. I haven't had a chance to check the clerk's office, but I currently have that open.
Is it? Oh,
There is, he had a
so
20
the violent might be juvenile because they're sealed.
He had a 2021 AGVAT, great bodily harm. In that case, the victim was Miss Perry, and it was declined to prosecute in September due to her being unwilling to prosecute it.
Was that the case from February?
It was, the arrest was March 1st of 2021. So there's an AGVAT, great bodily harm from that case. He had a 2020 resisting without, that was no prost. We had a 2019 BAT DV. In that case, the victim was Miss Jones. That was from October of 2019.
All right, thank you. At this time, Mr. Grooms, I'm going to place you on pretrial release and require that you post a monetary bond. However, I'll reduce that amount. On count 1, it'll be $150. On count 2, it'll be $2,500. And on count 3, it'll be $100. With special conditions, you can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon of any kind, firearm or ammunition. You must surrender the firearms that are in the house within 48 hours of your release from custody. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir. Thank you, ma'am. Good luck.
A moment to confer, Your Honor.
Yes.
I believe you just did no contact and no weapons.
Yes.
Are you doing a separate residences?
Yes, I
Did
said
miss
that.
it?
Your Honor.
Yes.
I've just been told the alleged victim doesn't live at the residence, so would you be inclined to adjust the order that if she's not there, he may return to his apartment?
I don't have to adjust the order. The order is maintained separate. I didn't say he can't go back there. So if she's not there, he can live there, but if she's there, he can't.
Your Honor, their addresses are the same.
Right.
Or the,
That's what it said, so. Don't, yeah, so as long as she's not living there, you're allowed to. I didn't say you can't. but you just can't live together.
Yes, ma'am.
Thank you, Your Honor.
Good luck, sir. Please tell me your name.
Shakespeare Jean-Gilles.
21 CF 13458, you're here charged with domestic battery by strangulation, false imprisonment, domestic violence, battery, domestic violence, and assault, domestic violence. I'm going to appoint an attorney to represent you in this case. There is probable cause. Give me
Honor.
one moment.
Your Honor,
Yes.
as to the assault, aren't those merged into the battery? If we
No, it's two separate crimes.
If we read through the affidavit, though, all I see were batteries, alleged batteries. I didn't see any.
Calm down or I'm going to effing kill you.
Was there an imminent fear from the victim?
His hands were around her neck.
I believe
while he
these
choked
crimes
her.
merge. I don't.
The officer and the state can find PC for both the higher crime as well as a lesser included if you're trying to argue that the assault is a lesser included of the battery. PC could be found for both, and arguably, if they are different instances, state could file both. But at this point, PC can be found for both, and the officer can charge both.
Yeah, it's two separate crimes.
So Your Honor would find PC for both?
I do. Your bond is $1,000 on count 1, $15,000 on count 2, $100 on counts 3 and 4. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't speak to her. You can't call her on the phone. You can't send a text message. You can't send a message through social media or friends and family. No contact at all. You understand?
Yes.
You can't possess a weapon of any kind, firearm or ammunition. Were you two living together?
Not here in Florida.
All right, I'll order you must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Yes.
Your Honor.
I'm sorry.
Yes,
It is
go ahead.
alleged that they lived in the same house back in Texas.
I said maintain separate.
Okay, I think he was just confused since he said they don't live together here, that your order does transcend to Texas as well.
So you understand you can't live with her?
Yes.
All right. Any other conditions the state would request?
No, Your Honor.
Good luck, sir. Please tell me your name.
Timothy Johnson.
You're here in 21 CF 13453, charged with sexual battery on a child under the age of 12 by a person over 18. There is probable cause. I'll appoint an attorney to represent you. Ma'am, are you a witness in this case?
Yes.
Do you wish to testify?
Yes.
All right, please raise your right hand to be sworn.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name.
Aquarian Critchlow.
All right, do you have any questions for her, Ms. May?
Yes, Your Honor. Good morning, Ms. Critchlow. What is your relationship to Samora Critchlow?
That is my daughter.
And how old is your daughter?
11.
Is there anything else you'd like to tell the court regarding his bond conditions?
I know he's been abusive to me. I want him to stay locked up.
How long were you in a relationship with Mr. Johnson?
3 years.
Okay. And was Samora around during those 3 years?
Not the first year.
Okay. Your Honor, that's all I have.
Mr. Brandt, do you have any questions?
No questions, Your Honor.
All right, thank you.
Your
Ma'am, is
Honor-
there anything else you want to tell the court?
No, ma'am.
Thank you. Yes, Ms. May?
Your Honor, given that he is charged with sexual battery on a child under 12 by a person over 18 with damage, it is a capital offense. So state is asking that you hold him no bond pending an Arthur hearing.
Any response from the defense?
No argument, Your Honor, but he is entitled to an Arthur hearing with his attorney.
He is. At this time, sir, you'll have no bond. However, even while in custody, you can have no contact with the victim or the victim's mother. Do you understand that?
I'm sorry.
Even while you're in custody, you cannot have any contact with the victim or her mother. Do you understand what no contact means? You can't call, you can't send a message through friends or family. No contact at all. You understand?
Yes, I do.
All right. He doesn't have bond at this time because this is a first-degree felony punishable by up to life in prison. However, he's represented by the Public Defender's Office, and they will likely file a motion to have a bond hearing downtown in front of a different judge. You need to stay in touch with the state attorney's office. You have a right to be at that hearing, and they'll make sure that you're there if you want to be.
Thank you.
Yes, ma'am. Good luck. Please tell me your name. A warrant was issued for your arrest in 21 CF 1284, charging you with domestic battery by strangulation and battery domestic violence. Another judge has already found probable cause. I'll appoint an attorney to represent you. Was he just released from DOC or probation?
Was released from DOC.
I've been working, it's my second day out of prison.
Sir, I'm sorry, I wasn't asking you. I was asking our staff if they could tell me. Because this is a PRR offense, isn't it?
Yes, Your Honor. I believe in that case, the one that he was recently released on, it was 2010 CF 16715. It was a burg dwelling with assault battery, attempted robbery with a firearm, possession of a firearm by convicted felon. And he got the 10-year min-man with 110 days credit time served.
I think this is a qualifying offense for a prison releasee reoffender.
It is.
So, all right, at this time, sir, your bond is $25,000 on count one, $100 on count two, with special conditions. You can have no contact with the victim in this case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. Good luck, sir.
Your Honor, you said 25,000?
I did. Please tell me your name.
Michael Scott Mumal.
Hold on one moment. (21 CF 13459). You're here charged with child abuse. I'm going to appoint an attorney to represent you in this case.
Your Honor, when setting bonds, state just asked that you set a high bond. The allegations in the affidavit are particularly troubling, including the injuries that the victim sustained, the child. I believe she is allegedly 14.
That's correct.
Your bond is $20,000. You can have no contact with the victim or the victim's immediate family. Do you understand what no contact means?
Yes, Your Honor.
You can have no contact with any minor child under the age of 18. You can't possess a weapon of any kind, firearm or ammunition, You must maintain a separate residence from the victim and the victim's immediate family members. I'll allow you to return one time with law enforcement to gather your belongings. You cannot be within 500 feet of the victim's residence or school after that one-time return. Do you understand?
Yes, Your Honor.
Good luck.
Your Honor, I believe DCF was called as well.
You must comply with any plan set in place by DCF. Or the school. Yes. This is a child, so not place of employment. Please tell me your name.
Jesus Manuel Suarez.
21 CF 13461, you're here charged with tampering with a witness to hinder communication to law enforcement and battery domestic violence. I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $5,000 on count 1, $100 on count 2. With special conditions, you can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. Any other conditions the state would request?
Your Honor, state also asked for no contact with a witness. I believe the
Said that.
child was there.
I said that.
And Your Honor, no information's been filed on that Allen Bond case.
It doesn't matter. At this time, I'm revoking your ROR in 21 CF 8963. Please tell me your name.
Remo, Emo.
21 MM 7235. You're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Give me one moment. Your bond is $5,000 with special conditions. You can have no contact with the victim, any witness in the case, or the victim's children. Do you understand what no contact means?
Yes.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand? Any other conditions the state would request?
No, Your Honor.
All right. Please tell me your name.
Erica Gessner.
21 MM 7225. You're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Does the state object to pretrial release?
No, Your Honor.
She was in the Navy as well, Your Honor.
I'm sorry?
She was in the Navy as well.
I see that. I also see that she has a mental health issue. Do you want to talk to her about being screened for mental health pretrial release?
Yes, Your Honor, just a moment. Thank you. Your Honor, I would just have you set straight PTR. I spoke with our client, and she has assured me that she's going to speak with someone, make an appointment, speak with someone immediately about any mental health issues she may be suffering from.
All right, at this time, I'm going to place you on pretrial release with special conditions. You can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. Good luck. Please tell me your name.
Marissa McCoy.
21 7234. You're here charged with battery, domestic violence, and battery. I'm going to appoint an attorney to represent you. There is probable cause here.
Your Honor, would you qualify for pretrial release?
It says no.
And state would object, Your Honor.
If they were re-interviewed, perhaps?
May I say something? Because they lied on their statement and they have.
Ma'am, you can say anything you want, but everything you say is being recorded and can be used against you later.
Your Honor, if you are inclined to put her on pretrial release, even though she doesn't qualify, state would object. It arguably could be filed as a burg that they're in, so state would object.
I see that.
Thank you, Your Honor. I would just have you set a bond, Your Honor. I don't believe Ms. McCoy has any questions for the court. But I don't see a very,
I'm sorry, what?
I don't see a criminal history. That's the only reason why I know they tried to contact, but the phone disconnected. But
All right, at this time, your bond is $500 on count one, $100 on count two. With special conditions, you can have no contact with the victims or any witness in this case. Do you understand what no contact means? You can't possess a weapon of any kind, firearm, or ammunition. You can't return to the victim's residence for any reason or be within 500 feet of it. Do you understand?
Yes, but how do I get my child back? Because I have custody of my son and he's at his dad's house.
You're going to have to talk to your lawyer about that. Wasn't the child in this incident, Miss May?
Well, he wasn't in this.
1 second, Your Honor. Yes, Your Honor, the child was present.
He was in the car.
Yes, Your Honor.
I'm going to order that you must comply with any plan set in place by DCF. Any other conditions the state would request?
No, Your Honor.
All right, good luck, ma'am. I think so. Yes.
Danny Rivera.
Thank you. You have a warrant for your arrest out of St. Lucie County for violating probation. At this time, there's no bond on that. We'll notify them that you're here so they can transport you, and I'll appoint an attorney to represent you in the meantime. Good luck, sir.
All right, so I'm waiting on transportation.
Yes.
Will that be today or?
I don't know. It's up to St. Lucie County, so.
Alice Byers.
09 CF 11542. You're here for a violation of probation. I'm going to appoint an attorney to represent you. There's no bond on this. And the allegations are that you committed new law violations, driving while license suspended, first-degree murder, possessing a weapon. So you'll need to call your attorney. Good luck, sir. Please tell me your name.
One Cantrell.
21 CF 13441, you're here charged with possession of MDMA and possession of cocaine. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000 on count one, $100 on count two. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
Yes.
21 CF 2673, you're here for a violation of probation. I show that he already has your office representing him on this. It's an on view. At this time, you'll have no bond. Good luck, sir. Yes. Please tell me your name.
Timothy Ratchford.
You're here for a violation of probation in 18 CF 16339. I'm going to appoint an attorney to represent you. At this time, there's no bond on this. The allegation is that you committed the new offense of possession of drug paraphernalia and driving while license revoked or suspended.
I've been locked up for 7 months in North Carolina. I just got extradited back here last night.
Okay.
I was asking, is there any way I could get a bond, seeing as I've been locked up for 7 months for this case?
No, I can't do that at this time, but call your attorney right away and they could file a motion in front of the trial judge. There's a lot more violations, so it's that you committed the offense of failure to stop at a flashing red light in North Carolina. Felony larceny in North Carolina. All right, there's the felony. Several counts of that. Obtaining property by false pretense. Failing to complete the impulse control class, which I'm assuming is because you were in North Carolina. Failing to complete 75 hours of community service.
My probation was I never had community service on my probation.
According to the affidavit, you do. So that's why you need to call your attorney right away. All right, good luck, sir. Interesting. Please tell me your name.
Thomas Riggs.
In 19 CF 9809, you're here for violating probation. I'll appoint an attorney to represent you. At this time, there's no bond on this warrant. The allegation is that you failed to comply with all instructions given, failed to successfully complete or remain in treatment. And that's it. All right, good luck, sir. Please tell me your name.
Whitmore.
19 CF 16677, a warrant was issued for your arrest for violating your probation. I'll appoint an attorney to represent you. At this time, there's no bond on this warrant. Get my computer to move. All right, sir, the allegations are that you committed the offense of DUI in June of this year, failed to successfully complete the impulse control class, failed to successfully complete 100 hours of community service, and failed to make your payments. Hold on one second. I think that's all the allegations. Sir, you can say anything you want, but everything you say is being recorded and can be used against you later. Do you understand that?
Your Honor.
Okay.
Mr. Givens is mental health.
20 203. Mr. Brandt, I'll appoint your office.
We'll waive the appearance, Your Honor.
All right, it's a VOP and there's no bond. Please tell me your name.
Jose Gustavo Gonzalez.
I'm sorry, who? All
Jose Gustavo Gonzalez.
right, I don't have him.
Gonzalez, Your Honor. Under misdemeanor and traffic VOP.
All right, hold on a minute. I don't have that phase sheet. I don't know why I don't have it. All right, I'll appoint an attorney to represent you in this case, sir. The allegation is that you violated your probation by committing the offense of domestic battery with a prior conviction and failed to pay your cost of supervision. There's no bond. Good luck, sir. Yeah, Mr. Brandt, do you want to enter a denial
He's telling
since
me
it's a
he already
misdemeanor?
He has an attorney on this already, he's told me. I don't know if there's an NOA.
Who's your attorney?
Elizabeth Narazinge.
No, we don't have anything in the clerk's file. Are you sure you hired her?
Yes, I did. She.
All right, so you need to call her right away then.
Will he be appointed in the interim, Your Honor? We can enter a denial so he can get a court date, and then he can get a new attorney if he chooses.
I mean, that's not the way it's supposed to work.
I'm sorry?
That's not really the way it's supposed to work, but
I understand, Your Honor.
I'll do that.
So I will enter a denial, Your Honor.
Okay. Yeah, doesn't matter to me. Sure. How was there already a date then? Well, then leave it. He already has a VOP date.
Tomorrow, or no, 10/19?
That's 6 days from now. All right, well, he has a court date.
10/19 at 9 a.m.
Is it at 9? Good luck, sir. Please tell me your name. You have a warrant for your arrest for violating your probation in 20 MM 364. At this time, there's no bond. I'll appoint an attorney to represent you. The allegation is that you failed to maintain the no contact with the victim. So the allegation is you had contact with the victim. All right, good luck, sir.
Do I have a court date already to you?
Mr. Brandt, do you want to enter a denial?
Yes, Your Honor. We'll enter a denial. That's the soonest.
Yes. Please tell me your name.
Christina Zarakowski.
You have 2 violations of probation, 19 CT 8425 and 20 CT 6624. I'll appoint an attorney to represent you in each of those cases. The allegations are that you committed the offense of possession of methamphetamine, possession of drug paraphernalia, driving while license suspended, and that you failed to impound or immobilize your vehicle as ordered.
The impoundment was actually a typo. It was supposed to be 360 days for both.
You'll have to address that with the trial court. But in 19 CT 8425, you have no bond. And it looks like in the other case, you have a bond of $3,000. Good luck, ma'am. Mr. Brands?
We enter a denial on the VOP with no bond so we can get a court date.
You don't want to do it on both?
We can do it on both, sure.
I'll do it on both.
Yes.
425, that's Division 63. And the DOP status date is October the 27th at 9:30 and 12 p.m. On the 364, that's Division 82. And then DOP status, November the 30th at 1:30 p.m. in 10 days.
I'm sorry, what was the courtroom? Madam Clerk? Is it, I'm sorry, Your Honor, is the case 19 CT 8425, is that the no bond status case?
Yes.
May I approach, Your Honor?
Yes.
I have updated 33 motions correct.
Oh, good. Because the very first one is not right. Yes. Okay, thank you. All right, is the state ready for 30? Doesn't matter to me. This is Judge Gibson. Who do I have on the line?
Good morning, Your Honor. This is Alan Figueroa, State Certified Spanish Court Interpreter, back on the line.
Has the interpreter been sworn?
Yes, Your Honor.
Please connect with the headset.
Sí.
The defendant can hear me, Your Honor.
Sir, please tell me your name.
Félix Vázquez Melgar.
Felix Vasquez Melgar.
21 MM 7238. Sir, you're here charged with battery. There is probable cause. I'll appoint an attorney to represent you in this case. Your bond is $500. You can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Bueno. Y esta es una fianza.
So this is the bond?
Actually, no, I'm changing that. I'm sorry. Your bond is $1,000. You can have no contact with the victim. Do you understand what no contact means?
Sí, okay.
Yes, okay.
You cannot return to the Chevron gas station located at 1635 West Oak Ridge Road.
Ajá.
You cannot be within 1,000 feet of the victim's residence. Are there any other conditions the state would request?
No, Your Honor.
No, no, yo pienso que ahorita no tengo teléfono, pero lo que yo pienso es de que si me dan la fianza para poder dar el dinero yo después, porque no tengo.
I don't have a phone right now, but I was just wondering if I could get like the amount of the bond so I can pay it later on.
The bond is $1,000. You'll have access to a phone here.
Pero no me recuerdo el número que me llevan allá. Donde fui arrestado.
I'm sorry, Your Honor. I'm just gonna instruct him to please face the mic because he's facing away from the mic and I cannot hear.
Ajá. No, yo digo si me llevan porque yo no me recuerdo del número de teléfono que tengo para poder llamar. Es cierto lo que usted me dice, pero no me recuerdo yo. Y yo pienso.
I understand what you're saying, but I don't remember the phone number for me to call.
You'll have to talk to your attorney. Call the number on that green piece of paper and speak with your attorney.
Okay.
All right, good luck, sir.
Okay.
Al número. Okay.
Please tell me your name.
Rivera Luciano. Samuel Rivera Luciano.
Samuel Rivera Luciano.
21 CF 13201, a warrant was issued for your arrest, charging you with arson of a dwelling. Another judge has already found probable cause. I'll appoint an attorney to represent you. Your bond is $50,000. You can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Entonces, ¿tengo el 10% o no?
Yes, so would I have to just pay the 10%?
That's between you and a bondsman. You can't possess a weapon, firearm, or ammunition. You cannot return to this scene for any reason or be within 1,000 feet of the victim's residence or place of employment. Do you understand that?
Sí, entiendo, pero es que todavía yo no sé de qué me acusan ni por qué, porque a mí nunca me entregaron ninguna clase de papel identificándome y por qué me arrestaron ni nada. Ellos llegaron a mi casa, me arrestaron, no me leyeron ni los derechos Miranda.
Yes, I understand, but I don't understand why I'm being arrested or why I was brought in here. I wasn't given any documentation. I don't know what the charges are. I just know that they showed up at my house and took me away. They didn't read me my Miranda rights.
Sir, I just told you the charge is arson of a dwelling. I'll ask the state to put the factual basis on the record, please.
It is alleged that on or about September 28th of 2021, law enforcement responded to the address at London Minor in regards to Ana Yvette Figueroa Rodriguez's apartment being set on fire.
That's not the address, counselor. That's the person's name.
At Alta Westgate Drive Apartments, number 4304. In regards to Ms. Figueroa Rodriguez's apartment being set on fire, there are obvious pour patterns and dark black soot on the concrete fiberboard directly below where the victim's bedroom is located inside the apartment. There was a witness that woke up and smelled smoke. After reviewing the video surveillance, law enforcement located what was a gold color late model Toyota Camry with sparkly aluminum rims, leaving the apartment complex at 4:08 a.m., approximately 8 minutes after the other witness smelled smoke. The victim identified this as the defendant's car, and that was him leaving. All events occurred in Orange County, Florida.
That's the factual basis for the warrant, sir. you can have no contact with the victim's children, or any witness in this case. You understand what no contact means?
Sí.
Yes.
Are there any other conditions the state would request?
No, Your Honor, not other than the no contact, the no weapons, and the no return you've already
Todavía
filed.
nada.
All right, sir. I want to make sure you understand, no contact means you cannot speak to her, call her on the phone, send a text message, send a message through social media, send a message through a friend or family member. This is no contact at all. All right, good luck, sir.
Your Honor, Mr. Mallett, his mental health.
21 MM 687, Counselor, I'm going to appoint your office.
We'll waive the appearance, Your Honor. I believe that.
All right, his bond is $500, no return, and must comply with all sex offender reporting requirements.
I think we finished Spanish, Your Honor.
I'm sorry?
I think we finished Spanish.
Oh, there are no more Spanish?
No, ma'am.
All right, so that's all we need from the interpreter. Thank you. All
No problem, Your Honor.
right, thanks for letting me know.
I forgot they were there.
Oh, no, I wouldn't know that, because you have to tell me that. All right,
Mr. Person, Darrell, is mental health.
I don't have that one. Hold on. 21 CF 13425, sexual battery on a child less than 12.
Yes, Your Honor.
I'm going to appoint the public defender's office.
Given that it's a first-degree felony punishable by life, state's asking that you hold him no bond pending an Arthur hearing.
All right, hold on one moment. There is probable cause, and I will hold him at no bond. Even while in custody, he can have no contact with the victim or the victim's immediate family members. And I don't know about this fugitive warrant. Rebecca, what do you know about that?
It's from Virginia. They are willing to extradite, and the charge is sexual assault.
All right, so,
He has a hold, so he's not.
all right, he won't be released, but he has no bond anyway.
He's entitled to an Arthur hearing, though, Your Honor, with his attorney.
Yeah, he'll have to do that downtown. All right.
Ronaldo Pacheco.
21 CF 13169. You're here because a warrant was issued for your arrest, charging you with sexual battery on a child less than 12 by a person greater than 18, and lewd or lascivious molestation on a victim under 12. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Ms. May, does the state wish to be heard?
Yes, Your Honor. Given that he's charged with 2 counts that are punishable by life, state's asking that you hold him no bond on both counts.
Anything from the defense?
No argument, Your Honor, but he's entitled to an Arthur hearing with his attorney downtown.
At this time, you'll have no bond on both of these charges. However, even while in custody, you can have no contact with the victim or the victim's immediate family members. Do you understand that?
Yes.
You understand what no contact means?
Yes.
All right, good luck, sir. Thank you.
One moment, Your
Okay.
Honor. Actually, we can start at the top of the ring, and I can just go out. Aquino Gonzalez is medical, Crystal.
21MM 7211, Mr. Brandt, I'll appoint your office.
We'll waive the appearance.
Wait, no, I will not. She has a private attorney. Huh. So was the attorney noticed for today? Then I think we need to reset this for tomorrow and make sure the private attorney was noticed because the PD cannot waive her appearance. She's represented by another attorney. Okay.
Cabrera, Yacel is medical.
21MM 6987, Mr. Brandt, you do represent him, sorry.
We'll waive their appearance and enter a plea of not guilty, Your Honor.
Division 85, pretrial conference is November 1st at 9 a.m., courtroom 4A.
Pompey is medical also.
21MM 4818, I'll appoint the public defender in this case.
We'll waive their appearance and enter a plea of not guilty, Your Honor.
Division 50, pretrial conference, November 8th, 1:30 p.m., courtroom 7C.
David.
21MM 6567, Mr. Brandt, your office represents him. It's a petty theft.
Yes, Your Honor, there's also an offer from the state, an adjudication of guilt, credit time served, no return to target at 120 West Grant, cost of investigation of $41.56 to OPD. And I did have a chance to speak with Mr. Turba David, and I believe he wishes to resolve this today.
Raise your right hand, sir.
Yes, ma'am.
All right, you had an opportunity, you put your hand down. Put your hand down. You had an opportunity to speak with an attorney about the rights you'd be giving up if you enter a plea of guilty or no contest to this charge. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
No, ma'am.
In addition to those rights, petty theft is what we call an enhanceable offense, which means after you've been convicted of so many, the state can file this as a felony. Do you understand that?
Yes, ma'am.
So I don't know, I'm not asking you this question. I don't know your history, so I don't know if you have any prior petty thefts, but this looks like it would qualify for one. So is it the third one, Ms. May, that can be charged as a felony?
With two priors, yes, Your Honor.
Right.
So the third.
So this counts as one, just so you know. You understand that?
Yes, ma'am.
You understand if you're on probation anywhere, this plea could violate that.
I'm not on probation.
I believe you, but I have to ask everyone,
Oh, okay.
because I don't know if you are. So I want to make sure you understand.
Sorry.
If you're not, it's okay. You understand, if you're not a U.S. citizen, you could be deported.
Oh, I am.
All right. Again, I have to ask everyone.
Okay.
With all this in mind, do you have any questions for me?
No, ma'am.
How do you wish to plead to the charge of petty theft of $100 or more?
No contest, ma'am.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 6 days you've been in custody. I have to order that you pay court costs and $41.56 for the cost of investigation. I'll also order that you cannot return to the target at the address your attorney put on the record earlier. I'll give you a year to pay all of this. Do you have any questions, sir?
Any questions?
I think she's at OBD. Again, that could be. But it's only.
Yes, sir.
All right, did you have any questions for me, sir?
No, ma'am.
All right, good luck. You have 30 days to appeal in writing.
Your Honor, Mr. Wallace is medical.
21MM 5313. I'll appoint your office, Mr. Brandt.
We'll waive the appearance and enter a plea of not guilty.
Conference, November 18th, 9 a.m., courtroom 9C.
Your Honor, Jordan Bradley bonded.
Okay. Please tell me your name.
Lawrence Delk, DELK.
21MM 7223, you're here charged with retail petty theft. Mr. Brantz, he's also out on bond for retail petty theft, so I'm going to appoint your office in this case.
Yes, Your Honor.
There is probable cause. I'm assuming there's not an offer.
There's not, Your Honor. It's also enhanceable.
Yeah. All right, sir. Your bond is $250. You can't return to the scene or have contact with any witness in this case. Do you understand that?
Yes, ma'am.
I'm going to take no action on that on bond case.
Your Honor, may I approach?
Yes. Oh, thank you. Please tell me your name.
Kia Downing.
21MM 7222, you're here charged with retail petty theft. There is probable cause.
Your Honor, I did convey an offer of a withhold correct time served, no return, and restitution in the amount of $7.47. However, I also informed defense that she may qualify for PTD downtown.
I don't know that I'll accept that offer.
Just a moment, Your Honor, to confirm.
Yes. Yes, I will accept it, if that's what she wants to do.
She has no other, the only other history she has is that disorderly intoxication, and due to
Right.
it being enhanceable, state didn't want to set her off on a bad foot.
And then I'm going to ask the attorneys to approach when he gets done talking to her.
We just asked for bond, Your Honor. I spoke with her. I believe she wishes to work with one of our attorneys to try to resolve this in a different way. Perhaps pre-trial
Right.
version, if applicable.
So it says that she doesn't qualify for pretrial release. Is that because you couldn't verify information?
We didn't get to interview her, so.
All right, so I'll order pretrial release if qualifies. If not, your bond is $100. You can't return to Circle K at 12390 East Colonial Drive. Do you understand?
Okay.
All right, good luck. Please tell me your name.
Matthew.
21MM 7227, you're here charged with trespass on property after warning. There is probable cause.
There was an offer from the state, Your Honor, and I did pass that offer on as well as a plea form to review to Mr. Matt. I believe he wishes to resolve it today, Your Honor.
He's out on bond for very serious charges. I'm inclined to revoke that.
I understand, Your Honor. He is willing to resolve this case today, and if you are inclined to revoke, I would just have you set a higher monetary bond. It is a simple trespass as opposed to a drug-related offense. Further, the 21 CF 8326, I don't believe has been filed on yet, and 21 CF 7618, there is at least according to our notes, a plea offer pending. He just hasn't resolved it with the attorney and the judge downtown yet.
What's the offer from the state?
It is an adjudication of guilt, credit time served, and no return.
On which case?
I'm sorry, Your Honor, which case?
Are you talking about the instant case?
Right, the others don't matter. I can't accept a plea on those.
It's an adjudication, credit time served, no return.
Not that they don't matter. They don't matter for purposes of me accepting a plea today.
It's not a jurisdiction, yeah, I got it.
Right.
I understand.
They very much matter.
You just asked a question after he said that there was a plea, that's why I was.
I see. All right, sir, raise your right hand, please.
Do you swear to tell the truth, whole truth, and nothing but the truth, after God?
Yes, ma'am.
All right, you can put your hand down. You had an opportunity to speak with an attorney about the rights you'd be giving up if you enter a plea of guilty or no contest today. Do you understand those rights?
No.
Do you have any questions for me about them?
No, ma'am.
You understand that if you're on probation, this plea could violate it? If you are?
Yeah.
And if you're not a U.S. citizen, you can be deported? Also, you heard me just say to your attorney, you're out on bond in 2 cases for very serious charges. At this time, this court has not decided if I'm going to revoke that bond. So you understand that even if you enter a plea to this trespass, I might still revoke your bond.
Yes, ma'am.
You understand?
Can I have
I think he
another-
said yes, ma'am. Is that?
He did say yes.
Okay, I'm sorry. I'm having a hard time hearing you, and I just want to make sure that I hear you.
Yes, ma'am.
That's okay. I just want to make sure I hear you right. Yes, sir, Mr. Brands?
Can I have another moment to confer?
Yes.
I just spoke with Mr. Math, and he's assured me that he hasn't been near drugs, and he won't be after these proceedings. He's participating with the judicial process, working with his attorney to resolve those out on bond cases, and he's willing to resolve the current case as well today.
All right, sir, understanding all of those things, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay those from the date of your release. I'll order that you cannot return to Maxwell Terrace.
Yes, ma'am.
You know where that is?
Yes, ma'am.
Okay, you can't go back there.
Yes, ma'am.
All right, on this case, sir, you have 30 days to appeal in writing. All right, at this time, I'll take no action on the out-on-bond cases. Good luck, sir.
Thank you, ma'am.
Yes, sir.
Were we appointed in that case at all? I know that.
I don't
took
think I did.
A little bit, okay.
No.
Yep, thank you.
Please tell me your name.
Maria Pernisi.
21 MM 7237, you're here charged with providing false identification to law enforcement. There is probable cause. I'll appoint an attorney to represent you.
There's not an offer at this time, Your Honor.
All right. Hold on one moment. Your bond is $500. At this time, I'm revoking your bond in 21 CF 3319.
Would you consider setting a higher monetary bond, Your Honor? I think the arrest affidavit indicates she was worried of the out on bond status, maybe fear of just
All right, I'll double that bond.
They only filed on the possession of meth charge.
All right. Was the bond $1,000?
That bond was only 150 because I guess they.
It was a
Tax them?
subsidiary.
All right, well, your bond will be $2,000. In the instant case, you cannot return to K&G at 350 East Michigan Street or have contact with any witness in the case. Do you understand? Good luck.
Morning.
Please tell me your name.
Carrie Santel.
21MM 7231. You're here charged with petty theft. There is probable cause. Is there an offer in this case?
No, Your Honor, it's enhanceable.
All right, I'll appoint an attorney to represent you.
Yes, ma'am.
Hold on. Your bond is $250. You cannot return to the dollhouse at 5744 North Orange Blossom Trail. Do you understand?
Yes, ma'am.
All right, good luck.
Okay. Am I released?
I'm sorry?
So am I released today?
So you have to post a bond to be released, but when you post it, you will be. Please tell me your name.
Gregory Sproul.
Good morning, sir.
Good morning, Jan.
Well, I guess it's afternoon now. Good afternoon. 21MM 7228, you're here charged with trespass on property after warning. Is there an offer in this case?
No, Your Honor, there was not, due to it being at Lake Eola when he recently pled on 10-9 to assaulting the park ranger at Lake Eola, that municipal ordinance.
Yeah, I remember that.
Would you accept a plea to the bench, Your Honor, of adjudication of guilt and credit time served on this trespass charge? And a no return as is one of the terms as well?
Your Honor, state would object, and if you were inclined to accept the bench offer, I'd ask that you look at the affidavit from the other case that he just pled to.
Was it not in front of me?
I believe it was, but
I remember
the
him.
assault and the word said to the park ranger, and it was at Lake Eola, and he's now, again, at Lake Eola, and again, being loud and making, I don't know if that's necessarily a threat, but vulgar statements to, again, park rangers.
Here's what I'd like to do, Mr. Brantz. I'd like to have your client screened for mental health pretrial release.
Your Honor, could our client address the court very briefly?
Yes, sir?
Yes, ma'am. Your Honor, I will never go back to that park. As a matter of fact, I'll catch the bus. I had the money to go back home now. And I just went there, and I had a conversation with the officer before I talked. Never, but we always just couldn't get along. I was ready to go yesterday. I would leave this courtroom, leave this town. I'm ready to go home, Your Honor.
Where's home, sir?
Chicago. I'm ready. I got the money and everything. I'm ready to go. I was going to leave then, but I ran into him just to happen. I ran into the officer. I'm ready to leave, Your Honor. I just went there to say goodbye to everyone I knew around there and leave.
I see. Well, the problem is you can't go back there.
I don't want to go. I'm ready to leave the whole city. That's where I was going. I'm going back. I got the money. I'm going home.
All right. Mr. Spurl, have you ever been diagnosed with a mental health illness?
Yes, ma'am.
Do you remember when that was?
Maybe now, been about 15 and 20 years ago.
What was it?
Schizophrenia, severe clinical depression and schizophrenia.
Are you suffering from any of the effects of that right now today?
No, ma'am, not that I imagine.
Were you yesterday?
Not that I can remember, no, ma'am.
When you ran into the park ranger, you weren't suffering any effects of?
Just with, me and him always had words together for each time. It just happened. I don't even know the man's name, but I know that every time we see each other, it's something.
Right. Give me one moment, I'm reading.
All right.
All right, thank you for your patience, sir. I had to ask some questions about this program. All right, so Mr. Spuriel, did you have a chance to speak with Mr. Brantz about the rights you'd be giving up if you enter a plea of guilty or no contest?
Yes, ma'am.
All right, so right now you understand the state hasn't given you an offer and you don't know what your sentence is going to be because you're pleading to the bench.
Yes, ma'am.
So is this a first or second degree misdemeanor, Ms. May?
As charged,
I think it's a first.
I believe so too, but I wanted to check.
Oh, okay.
It is, Your Honor.
It's an M2?
It's M1.
M1, okay. So this charge is a first degree misdemeanor, which is punishable by up to a year in jail. So I want to make sure that you understand that. I'm not telling you I will sentence you to a year in jail, but I could. That's a lawful sentence in this case. Do you understand that?
Yes, ma'am. Yes, Your Honor.
Knowing that, do you think you still want to enter a plea today?
Yes, ma'am.
Has he sworn in? Have we sworn him in? Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right, so you understand the rights you're giving up if you enter a plea today.
Yes, ma'am.
We're not going to have a jury trial. You're not going to call any witnesses. You're giving up your right to remain silent. You understand all that?
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am.
Did you have a chance to review the plea form?
Yes, ma'am.
All right, that further explains your rights. Do you have any questions about that?
No, ma'am.
All right, sir, you understand if you're on probation anywhere, this plea could violate your probation.
Yes, ma'am.
And if you're not a U.S. citizen, you could be deported.
Yes, ma'am.
How do you wish to plead to the charge of trespass on property after warning?
Guilty.
All right, sir, I accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty. Mr. Spuriel, where do you have this money for the bus that you're going to take to Chicago?
It's in my property.
When you got arrested and brought to jail?
Yeah. I'm gonna go, I got 100, and I got some more that I gotta get to. But I got 100 with me now in my bag they took from me, 87
They
plus
probably took
90.
the fee out, because now it's only like $87.
Yeah. Okay, something like that. But
Okay. All right, so I think I've seen you before. Do you remember me?
yes, ma'am, I believe I do.
Because I think I told you before that you can't go back to Lake Eola.
No, but that was when, but it was over with. I went to the office and it gave me a year, and the year had went gone. That's why I started going back. The year was up. I went to the office, and they got it clarified that my time was up, that I did the whole year without going there. And my time was up, and I can go back. And I start going back, and then I run into the same office that I ran into, that got me into it before. It's the same one.
All right, so when I tell you today that you can't go back there, do you understand that you can't go back for any reason?
Yes, ma'am, I'm gonna leave. I told you I'm gonna leave. I'm going to catch the Greyhound bus.
But not from Lake Eola?
No, ma'am, I'm going to the bus station just as soon as I get there, and I'm gonna sleep there till I get there on that bus.
Well, don't sleep there, because then you
All
might
right.
get arrested for that,
No,
so.
I'm gonna get my ticket, and catch the first thing they got leaving, because I don't want to go through that no more. It's not going to, me and him, I just see that. Listen, I like the lake, but I don't like what happens.
All right, sir. I'll give you the credit for the 2 days that you've been in custody. I have to order that you pay court costs. I'll give you a year to pay them. You cannot return to Lake Eola Park for any reason.
Yes, ma'am.
All right, good luck, sir. You have 30 days to appeal in writing.
All right.
I just spoke with Mr. Spurriel as a friend of the court, Your Honor.
Did I appoint the PD?
I don't believe
Didn't.
so. Yeah.
Good luck, sir.
Thank you.
May I approach, Your Honor?
Yes.
Your Honor, Mr. Corey Petit, his mental health.
21 MO 1173. I'm going to appoint your office, Mr. Brands.
We'll waive the appearance, Your Honor.
There is probable cause.
It was mental health as the reason, officer? Thank you.
I mean, do you want to see if you can bring him back tomorrow? Or no?
I don't know if a mental health episode can be resolved in that short of time, so I would just waive now and
All right. Do you have the bonds? I'll stay the bonds with a no return. Hold on. 250 and 250. I'll stay the bonds. He's not allowed to return or have contact with any witness in this case. Please tell me your name.
Hi, Brian Crittenden.
21 MO 1174. You're here charged with possession of graffiti paraphernalia. There is probable cause. Was there an offer?
No, Your Honor, there was not.
I show that he's on probation as a violent felony offender of special concern.
Yes, yeah.
All right. Your bond is $500. You're not allowed to return for any reason or have contact with any victim or witness in the case. Do you understand?
Yes, ma'am.
All right, good luck, sir.
Is there any way to resolve this today?
There is not,
Okay.
and you're being held for the violation of probation, so we'll know soon if there's a warrant for that.
Thank you, ma'am.
Yes, sir, good luck. Please tell me your name.
Sebastian Louis Martin Fernandez.
21 MO 1175. You're here charged with disorderly conduct.
Yes.
There is probable cause. Was there an offer?
Yes, Your Honor, I've been authorized on the city's behalf to offer a withhold credit time served.
I did have a chance to speak with Mr. Fernandez. I conveyed the offer as well as handed him a plea form to review, and I believe he wishes to resolve it today.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
I affirm.
All right, thank you, sir. You had a chance to speak with an attorney about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, I do.
Do you have any questions for me about them?
No, I don't, ma'am.
Did you review that form in front of you? It further explains your rights.
Yes, I did, ma'am.
All right. You understand that if you're on probation anywhere, this plea could violate that.
Yes, I do, ma'am.
You understand if you're not a U.S. citizen, you could be deported.
Yes, I do, ma'am.
All right, sir, how do you wish to plead to the charge of disorderly conduct?
I plead no contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay those. Sir, I see that you're a veteran.
Yes, ma'am.
Were you in the Army?
Army for 14 years and reserves for 3 years.
Thank you for your service.
Thank you, ma'am.
You'll be released after this, but you know that we have a lot of VA support here in this area.
It's way better than most areas, and I started going back. I'm currently Baldwin Orange team.
Okay. I just want to make sure you know there's support.
I stopped shooting up, and my life's going the right direction. I just made this one mistake because my girl didn't start her job at McDonald's. So I made the mistake as a man.
All right, well, good luck, sir. You have 30 days to appeal in writing.
Thank you.
Okay.
It's getting better.
Please tell me your name.
Interest price, ma'am.
21MO1176. You're here charged with disorderly conduct. Was there an offer?
Yes, Your Honor, I've been authorized on the city's behalf to offer a withhold credit time served.
I did convey that offer, Your Honor, to Mr. Price, as well as send him a plea form, and he did review it, and I believe he wishes to resolve that today. Although I do want the record to show that it was a bagel that was the object of the
I know.
transmission or the city ordinance passing. Kind of silly, but.
I know.
Ordinance is being in the road, not what's.
Right, the problem is there's probable cause for being in the road.
Well, I understand, but I think the statute or the ordinance also says.
Wait, say that again?
Not a statute, an ordinance. The ordinance says one cannot pass an item from someone into a car, and they cannot receive an item from someone in the car too. So the bulk of the ordinance is more so about, they could be on the side of the road and still transfer items and still be in violation of the ordinance. Could be a road map too. I guess would be a violation as well, but I just wanted the record to show I don't have an argument on PC though.
Yeah.
Because it does fall within the ordinance.
I don't disagree with you. I don't like these cases, but I'm stuck with them. All right, Mr. Price, raise your right hand, please.
You gotta tell the truth, whole truth, and nothing but the truth, help you God.
Yes, ma'am.
You can put your hand down. You had the opportunity to speak with an attorney about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
No, ma'am.
You had a chance to review that form in front of you?
Yes, ma'am.
It further explains those rights. Any questions about the form?
No, ma'am.
You understand if you're on probation anywhere, this plea could violate it?
Yes, ma'am. Yes, ma'am.
Thank you. You understand if you're not a U.S. citizen, you could be deported?
Yes, ma'am.
At this time, how do you wish to plead to the charge of disorderly conduct?
No contest, ma'am.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay that. Do you have any questions for me?
No, ma'am.
All right, good luck, sir. You have 30 days to appeal in writing. Please tell me your name.
Anthony Brooks.
21 CF 12305. A warrant was issued for your arrest, charging you with burglary of a conveyance with a battery therein, tampering with a witness in a first-degree felony punishable by life offense, robbery, and extortion. Another judge has already found probable cause in this case. I will appoint an attorney to represent you. State wish to be heard.
Yes, Your Honor, as to count 1 and count 2, both are punishable by life offenses. State's asking that you hold a no bond pending an Arthur hearing.
Mr. Brantz,
No argument, Your Honor.
I will do that. At this time, you'll have no bond on counts 1 and 2. Counts 3 and 4, your bond is $25,000 each. Count 5, it's $5,000. You can have no contact with any victim, witness, or co-defendant in this case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You can't return to the scene for any reason. Any other conditions the state would request?
No, Your Honor.
All right, good luck. Please tell me your name.
Anthony Calabro.
21 CF 13305. Hold on one moment. A warrant was issued for your arrest, charging you with burglary of a dwelling, criminal mischief, and grand theft. Another judge has already found probable cause. I'll appoint an attorney to represent you. Your bond is $5,000 on count 1, $250 on count 2, and $500 on count 3. You cannot return to the scene for any reason. You can have no contact with any victim, witness, or co-defendant. You can't possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes, ma'am.
In 21 CF 13307, a warrant was issued for your arrest, charging you with burglary of an occupied structure and petty theft. Another judge has already found probable cause. I'll appoint an attorney to represent you. Your bond is $5,000 on count 1, $100 on count 2, with the same conditions. You can't return to the scene, no contact with any victim, witness, or co-defendant, and you cannot possess a weapon, firearm, or ammunition.
But I don't have any holds, ma'am. I can bond out.
You can bond out.
I don't see any holds.
Thank you.
Yes, sir, good luck. Please tell me your name. 21 CF 6436. A capias was issued for your arrest for failing to appear for a case management conference on a charge of battery with a prior offense. There's no bond authorized, and I'll appoint an attorney to represent you. Good luck, sir. Tell me your name, please.
Julie Dort.
21 CF 3598. A capias was issued for your arrest for failing to appear for a pretrial conference on charges of possession of cocaine and drug paraphernalia. The bond authorized is $5,000 on count 1, $100 on count 2. I'll appoint an attorney to represent you. Good luck. Please tell me your name.
Hafiz Ferguson.
21 CF 13445. You're here charged with possession of a controlled substance. I'm going to appoint an attorney to represent you in this case. There is probable cause. Hold on one moment. Your bond is $1,000. You can't possess or consume any controlled substance without a valid prescription. You can't have contact with any known drug dealers. You can't have contact with any co-defendant in this case. Do you understand?
Yes, ma'am.
At this time, I'm revoking your bond in 21 CF 13234. Good luck, sir.
Your Honor, Jemiah Jackson's behavior.
21 CF 11477. Mr. Brantz, I'll appoint your office.
Waive the appearance, Your Honor.
It's a warrant, so there is probable cause. The bond is $3,500. Is there only one count or two?
There's only one, Your Honor.
All right. No victim contact, no witness contact, not returned to the scene for any reason. And Counselor, your client has a hold out of another county.
Yes, Your Honor.
Your Honor, State would also ask for no weapons.
No weapons, firearms, or ammunition.
Thank you.
Please tell me your name.
All right, Keenan.
In 21 CF 9683, a capias was issued, and then an information was filed, charging you with petty theft with 2 prior convictions and trespass in a structure. The bond authorized is $2,500 on count 1, $150 on count 2. I'll appoint an attorney to represent you. In 21 MM 7230, you're here charged with possession of drug paraphernalia. Give me one moment.
Your Honor, state will go ahead and announce no information on that.
The state's dropping that case against you. Good luck, sir. Thank you, Ms. May. Please tell me your name.
Karina Kuhn.
21 CF 13442. You're here charged with retail petty theft and use of an anti-shoplifting control device. I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $1,000 on count 2, $100 on count 1. You cannot return to the scene for any reason. Do you understand?
Yes, ma'am.
All right, good luck.
I have a moment, Your Honor.
Yes.
So that's 1,000 on the shoplifting device? So we
Yes.
swapped it? Okay.
Please tell me your name.
Jeremy Chad Ludwig.
21 CF 9791, a warrant was issued for your arrest for possession of fentanyl and drug paraphernalia. Another judge has already found probable cause. I'll appoint an attorney to represent you. The state filed an information. Your bond is $1,500 on possession of fentanyl. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Good luck.
Thank you.
The state didn't file the paraphernalia? No. Mm-hmm. Please tell me your name.
Mark McClendon.
21 CF 13444. You're here charged with possession of a controlled substance. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You can have no contact with any known drug dealers or any co-defendants in this case. Do you understand what no contact means? You can't possess or consume any controlled substance without a valid prescription. At this time, I'm revoking your bond in 21 CF 2599.
Say that again, ma'am.
I'm revoking your bond. You were out on bond for carrying a concealed firearm and possession of cocaine. I'm revoking it at this time.
Just a moment, Your Honor.
Okay. Good luck, sir. Please tell me your name.
Sylvia Middleton.
21 CF 13451. You're charged with possession of cocaine, cannabis, and drug paraphernalia. In 13452, you're charged with possession of fentanyl and paraphernalia. There's probable cause for all of these charges. I'll appoint an attorney in both cases. Your bond is $1,000 on count 1, $100 on counts 2 and 3. And then in the other case, it's $1,000 on count 1 and $100 on count 2. You can have no contact with any known drug dealers. You cannot possess or consume any controlled substance without a valid prescription. Do you understand?
Yes. Yes.
All right, good luck.
Kara Moyes.
21 CF 12648, you're here charged with robbery with a firearm and petty theft. A warrant was issued for your arrest, so another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Yes, Ms. May?
Your Honor, given that she's charged with the first-degree felony punishable by life, state's asking that you hold her no bond pending an Arthur hearing.
Any response, Mr. Brantz?
No argument, Your Honor.
At this time, you'll have no bond on count 1. On count 2, it's $500. You can have no contact with any victim, witness, or co-defendant in this case. Do you understand what no contact means?
Yes.
You can't possess a weapon of any kind, firearm, or ammunition. I'll order you must surrender the firearm, any firearms you have to law enforcement within 24 hours of your arrest. Of your release. You can't be within 500 feet of the victim's residence or place of employment. Any other conditions the state would request?
No, Your Honor.
All right, good luck. Please tell me your name.
My name is Hung Tan Nguyen.
Sir, you have 2 cases here, 21 CF 13419. You're charged with grand theft of a motor vehicle, 20 CT 4489. A capias was issued for your arrest for failing to appear on a charge of no motor vehicle registration. I'm going to appoint an attorney to represent you in both of these cases. Give me one moment.
Hold on.
All right, sir, I want to make sure you understand that. I'm not asking you any questions. You can say anything you want, but everything you say is being recorded and can be used against you later. Do you understand that?
I don't understand.
You don't understand? Is that what you said? Okay, so I'll give you a moment to talk to your attorney, but everything we do in this courtroom is being recorded. That's why there's a microphone. So you can tell me anything you want and ask any questions you want. Let me give you a moment to confer with your attorney, and then we'll come back.
A lot.
Thank you, Your Honor.
All right, sir.
So what I need to do the next one?
All right, so the capias that was issued for you for failing to appear, that judge set the bond at $5,000. I cannot change that bond. So you'll have to post that in order to bond out. You're going to call the number on that green piece of paper to talk to your attorney.
Okay.
As for the bond in this grand theft case, I'm going to reduce that bond to $500. So that's the bond that you have to post to get out.
Okay,
and you need to stay in touch with your attorney. So call that number right away.
okay.
Your Honor, are there any conditions on the new law?
Thank you so much.
No? All right, good luck, sir.
My name is Robert Nickerson.
21 CF 13454. You're here charged with possession of cannabis with intent to sell or deliver, possession of cannabis over 20 grams, and possession of drug paraphernalia. There is probable cause, and I'll appoint an attorney to represent you. In 21 CF 13455, you're charged with possession of MDMA, possession of a prescription drug without a prescription, and drug paraphernalia. There's also probable cause for those charges, and I'll appoint an attorney to represent you. Give me one moment.
Your Honor, given that this was one incident, it's just two different officers' reports. He has paraphernalia on both, so they would just ask you ROR as to one of them.
I will do that. Your bond is $1,000 on the possession of cannabis with intent to sell or deliver. 100 on count 2 and 100 on count 3. In the other case, it's 1,000 on count 1, 150 on count 2, and ROR on count 3. You can have no contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. Do you understand?
Yes, ma'am.
At this time, I'm revoking your bond in 21 CF 5698. Good luck. Please tell me your name.
Sarah Roman.
A capias was issued for your arrest for failing to appear for court in 19 CF 6570. The bond authorized is $2,000 on count 1, $1,500 on count 2, and I'll appoint an attorney to represent you. Good luck.
Thank you.
Please tell me your name.
Scott Singleton.
21 CF 2279, a warrant was issued for your arrest, charging you with criminal use of personal identification information, scheme to defraud, fraudulent use of credit cards, exploitation of an elderly person, and grand theft. Another judge has already found probable cause. I'll appoint an attorney to represent you. What is this? Absconder, fugitive?
I guess meaning she hasn't been reporting to probation.
But is there a warrant on that?
It's a 5-day hold, the VFOSC hold on her.
Okay. What's she on probation for?
Like grand theft, of motor vehicle on 3 cases, and a burglary, and criminal mischief on another case.
Thank you.
Ma'am, what's the 5-day hold thing?
So it looks like you're on probation. And so the hold is to see if they're going to issue a warrant for violating your probation. I don't know at this time if they will.
Okay.
Give me one moment, I need to read something. All right. Did the state file the information with these same charges, Ms. May? 1, 2, 3, 4, 5. It looks like it.
No.
Oh, no, I see 4 fraudulent use of a credit card, 1 scheme to defraud.
We have a fraud, number 1 is fraud use of an ID, a person over 60 years old, which is an F2. So 1 is different. Count 2 is a scheme to defraud over $20,000. So that's an F3. And then 3 counts of fraudulent use of credit cards over $100, all F3s. So 1 F2 and 4 F3s.
At this time, your bond will be $15,000 on count 1. $5,000 on count 2. And $1,000 on 3, 4, and 5. With special conditions, you can have no contact with the victim or the victim's immediate family members. Do you understand what no contact means?
Okay, so on the $15,000 bond,
Hold on, answer my question. Do you understand what no contact means?
Yes, ma'am.
All right, go ahead. Do you have a question?
Yes, ma'am, I do. On the warrant that I was issued, I didn't have a fraud of over $20,000 at all, because I didn't.
Right, so there was a warrant issued for your arrest. Subsequent to the warrant, the state filed an information, which is the charging document. So what they've charged you with is different than what was in the warrant.
So basically, I am being charged for something over $20,000.
Ms. May, what are the charges?
That was what it says on our case management system. On the actual information, it has fraud use of a personal identification information of a person 60 or older at F2.
Yeah.
The scheme to defraud, the F3, the fraud use of a credit card to obtain more than $100 in value, F3. Same thing for count 4, same thing for count 5.
And count 2, the scheme to defraud also says of a person 65 years of age or older. That's what the information says.
They did have a problem with my information at booking because they were trying to find statutes, and they did change some stuff in booking that was not supposed to be changed.
It's because the warrant is different than the information. So the state is who's prosecuting you, and they have the authority to charge whatever they want, that they can reasonably support.
Okay.
So they changed the charges, and I'm changing the bond. So you can have no contact with the victim or the victim's family. You can't return to the victim's home or be within 1,000 feet of the victim's residence. Do you understand?
Yes, ma'am.
Any other conditions the state would request?
No, Your Honor.
You can't have contact with anyone over the age of 65. So you have to stay away from people over 65.
Yes, ma'am. Is there a way I can get my affidavit and my charges?
So I've appointed an attorney to represent you. What'll happen is they'll file a demand for the discovery, and the state will have 15 days to respond to that. And then they'll give it to you.
All right.
All right, good luck. Yeah, because that case doesn't exist anymore. Right. So I think still reset it for tomorrow, but if they don't, he can consider that if he wants. It's not technically right, because it's the wrong case, because this doesn't exist now. So he might not know that this exists, and he might want to enter a plea on this, you know? So yeah, we gotta still reset it. Thanks. Please tell me your name.
Tristan Jefferson Stewart.
20 CF 14689, a capias was issued for your arrest for failing to appear on a charge of a burglary of a dwelling. Your bond is $5,000, and I'll appoint an attorney to represent you. Good luck.
Thank you so much. You have a great day.
You as well. Please tell me your name.
Michael H. Tudor.
21 CF 13450, you're here charged with aggravated battery with a deadly weapon. I'm going to appoint an attorney to represent you.
With a deadly weapon?
Yes.
There was no deadly weapon. Okay, hold on.
So I'm going to give you a minute to talk to your attorney.
Thank you, Your Honor.
All right, sir. There is probable cause. The allegation is that you hit someone with a board. So that's probable cause at this stage. Your bond is $2,500. You can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm or ammunition. Where did this take place?
At my home.
It's your home?
Yes, ma'am.
Does he live there?
No.
Okay. So you have no reason to return to his home you have no reason to return to his home?
Pardon me?
I'm saying you have no reason to go to his house.
I don't have any reason to go there at all.
Okay. I'm going to leave that. Any other conditions the state would request?
No, Your Honor.
I'm inclined to revoke his out on bond case, counselor.
I believe it was a notice to appear or a summons. I don't know if he's out on.
Oh, so he's not out on bond. All right, good luck, sir.
I need that.
Call us.
Please tell me your name.
Adam Turner.
21 CF 13443. You're here charged with grand theft of a motor vehicle. At this time, I'll appoint an attorney to represent you. There is probable cause. Your bond is $1,000. You can have no contact with any victim or witness in this case. Or co-defendant. Do you live in this area, Country Club Drive?
No, ma'am.
All right, you can't return to that area. Any other conditions the state would request?
No weapons, firearms, Your Honor.
All right, I'll order you're not allowed to possess a weapon of any kind, firearm, or ammunition. And at this time, I'm revoking your out on bond case, 21 MM 7098. Good luck, sir.
Virgilio Vargas.
21 CF 9662. A warrant was issued for your arrest, charging you with aggravated battery with a deadly weapon, battery, and criminal mischief. Also, I see the state filed an information. So another judge has already found probable cause, and the state filed an information. I'll appoint an attorney to represent you. Give me one moment.
Yes, Your Honor, it originally came in as an M1 battery, and we ended up charging these 3 charges, the F2, the M1, and the M2.
All right, your bond is $10,000 on count 1, $500 on counts 2 and 3. You can have no contact with any victim or witness in this case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You can't return to the scene for any reason. I show that you're a violent felony offender of special concern, and you might be on state probation, so you have a hold for that right now,
Why?
because it looks like you're on probation for sale or manufacture
This was
of...
a year. This happened a year ago, and the case was against my lady and her sister, and it got dropped against my lady because they found out the statement that the other girl wrote was insufficient. It was not true at all, and she beat it, and she got.
Hold on. Your Honor, could I have a moment to look up what
Your
is
Honor.
that?
That's what I'm saying. I'm not understanding.
I'm not
because
revoking anything. I'm just telling him there's a hold.
Yeah, we went to court, and the court, it was dismissed at court against my lady because the initial fight happened with them two. And I'm not understanding. She lied on me, and that's why.
So what happens is every time you're arrested, if it looks like you're on probation or community control or something like that, there's a hold placed on you till they can investigate and determine if there's going to be a warrant issued for your arrest. So if you weren't on probation when this occurred, there won't be a warrant.
I wasn't.
But I don't know that.
This happened a year ago. I just got on probation like 3 months ago.
I believe you. I'm just telling you there's a hold. There's nothing I can do about that.
There's no way you can lift the hold so I can go to work?
I cannot. I don't have that information.
What information do you need?
It did state the VOP is to be completed by Olga Bryant.
Yes, I spoke to her as well the day I got locked up yesterday, and she said that this is not going to violate me or nothing. It's not
It may not. I'm not telling you that it will.
I'm just saying, I'm just trying to get back to work.
There's nothing I can do about the hold, though, because I don't have the information.
What information? That's what I'm saying. What information? Because it's all on court record. Everything, the case with her and my lady that got dismissed against my lady that she called the police, that the girl called the police, it got dismissed with her because her sister was lying. She lied in the police report. Her grandma even said that she was the aggressor and everything. Even at court, it was dismissed against my lady. And I was her witness, and I'm not understanding why.
I don't think it being dismissed against.
It was.
No. Listen to what I'm saying. That doesn't have any effect on your case. That's her case. This is your case.
What case?
So you keep saying it was
That she
dismissed against
lied?
your lady.
That
I don't
she lied
know.
on me and
Okay,
her. That's
look,
what I'm not
sir,
understanding.
listen. I need you to listen. You're not understanding because all you're doing is talking.
I do understand, ma'am. I'm just trying to get this lifted off me so I can go back to work.
I'm telling you I can't do that. You keep talking, but you're not listening. I don't have control over this hold, so I can't change it.
You said you needed to see something?
So that case is not in front of me. So there's nothing I can do about that hold today. So the way the holds work is,
There's no way.
I don't have all the information. That case is not in front of me. So if you're right and you were not on probation, the hold will be released and there won't be a warrant issued for your arrest. You said you spoke with your probation officer. If that's who's going to issue the warrant or not, and she's already told you she's not, then you know that she's not.
Yeah, but I don't want to sit in here longer than I have to, man, because I'm missing days of work.
I understand, but I can't change that.
So what do I need to do to speed up this process? Or anything?
Call your probation officer.
You said I did call her.
Okay.
Call her twice.
Call her again.
And say what?
Call your attorney on that piece of paper.
And what do I say exactly so I can get this situated?
I can't give you legal advice.
That's not legal advice. You just told me to call her so I can.
David Williams.
Hold on a minute. I gotta get your case. Please tell me your name. Oh, David Williams.
Yes, ma'am.
All right, you have two cases, 21 CF 13440 and 21 CF 13464. You're charged with possession of cannabis with intent to sell or deliver, possession of cannabis greater than 20 grams, driving while license suspended, third or subsequent violation. There is probable cause. I'll appoint an attorney to represent you. The other case, a warrant was issued for your arrest, charging you with possession of a firearm by a convicted felon and possession of ammunition by a convicted felon. Another judge has already found probable cause in that case. I'll appoint an attorney to represent you in that one as well.
Yes, ma'am.
In that one, your bond is $4,000 on count one, $5,000 on count two.
Yes, ma'am.
In the possession of cannabis case, give me one moment. Your bond is $1,000 on count one, $1,000 on count two, and $2,500 on count three. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. You also can't drive without a valid Florida license. Do you understand?
Yes, ma'am.
At this time, I'm revoking your bonds in 21 CF 11554, 21 CF 11552, 21 CF 11531. Good luck, sir. Please tell me your name.
Amanda Workman.
21 CF 3557. A capias was issued for your arrest for failing to appear for arraignment. There's no bond authorized, and I'll appoint an attorney to represent you. Good luck. Anything else before court is adjourned?
Nothing from the state, Your Honor.
Nothing from the defense.
All right, thank you.